Thank you. I got a couple of questions for our witnesses. Various witnesses have noted that Section 10, 1.1 of the bill provides direction to the CRTC on drafting regulations. It outlines various matters that the Commission must consider in establishing whether a program or project meets the criteria of Canadian content. Some of you have argued that this definition should remain flexible and have suggested that the section be amended to indicate that no one factor should be determinative. This very amendment was proposed on the House side, but was rejected by the government. Do all the witnesses continue to see such an amendment as being important? And can you explain to us in a little bit of background why or why not, if you believe not? And what do you see as the consequences for investment in Canada if flexibility fails to be incorporated into this bill, and in terms of how Canadian content is defined? Who wants to?
I'm happy to begin on.
Sure.
So, thank you very much for the question. I'm happy to begin on the need for flexibility around the definition of Canadian content, and indeed the amendment that you highlight, that no single factor should be determinative in determining what constitutes Canadian content. I think that what's relevant, what's so important to us about that is I've identified 3 Canadian stories that we've produced: Barkskins, Turning Red, and Washington Black. They do not constitute Canadian content because the Walt Disney Company owns the intellectual property of that content. On the flip side, there are situations where content will be identified as Canadian content, even though it doesn't tell a Canadian story. It's not produced in Canada. However, it meets the point system, and the IP is owned by a Canadian. Therefore, what we're trying to do is rectify that anomaly, right? So that there's a flexible definition such that works like Turning Red, Barkskins, and Washington Black can actually qualify as Canadian content. The mere fact that we own the intellectual property shouldn't disqualify that when the work is produced in Canada, telling a Canadian story. And indeed, Turning Red had a whole host of, was directed by a Canadian and a whole host of Canadian cast and crew on it. And so that's why that amendment is so important to us.
Anybody else want to comment on that? Mrs. Smith?
I think probably my colleague and I would both like to. I think it's a great question and a reason why Spotify is here in support of the objectives of the bill, but hoping to get greater clarity. A lot of those issues and what's currently in the draft legislation is pretty specific to the video production side. Obviously, the Broadcasting Act in general originated with radio and television. Regulating audio streaming is a first of its kind in the world legislative proposal, and we think there should be also specific guidance for this sector, given the uniqueness of this side of the industry. The scale of music repertoires or of audio repertoires in general on streaming platforms, they are comprehensive, and that is different than for video platforms such as Disney Plus. We think in light of that, the obligations with respect to promoting Canadian content should be recognized as needing to accommodate some business reasonable judgments that all platforms will need to make to ensure that they're still incentivized to promote music that we all sort of colloquially recognize as Canadian, but may not fit into the strictures of the prior system.
Yes, I mean, Spotify has a few ways of identifying Canadian content as it stands now. One of them is through our own application called Spotify for Artists, where artists have the ability to pitch their music for playlist inclusion. We've democratized the process in which music gets to our team of editors. And through that process, they have that opportunity to identify themselves as Canadian. We have that option, as well as working with Gracenote, which is an international entertainment data company that will identify country of origin. And the last point is just the trusted and direct relationships that we do have with rights holders in Canada across the record label, publisher, songwriter system, identifying Canadian artists. And again, Canadian artists are making music not in Canada. Some in the country music industry are moving to Nashville to create country music. and writing with potentially international writers and collaborating with producers and recording in studios that may not be in Canada. However, if that artist is from Canada based on country of origin, we would still call them a Canadian artist. So some of the flexibility in what we currently define in CanCon is basically taking the broadcast definition of CanCon into the streaming environment should be updated before it gets done.
If I could just add, building off of what was just said, I think, we heard a lot on the first panel and have heard a lot throughout the process of looking at this bill, that these are regulations and a law that hasn't been looked at in decades. And it stems from a time when all of the media creation was inherently local, and, much broadcasting still remains an inherently local medium. What I think you are hearing from Spotify, from me, from Mr. Ferris, is that we are in a much more global and dynamic both production market and creation market and distribution state. And so this is an area where regulations built for a different type of industry, like a music industry that existed 30 plus years ago, don't reflect how music is created and who it is being created by today.
Thank you. Question I have is for Mr. Levin. I heard in your testimony, and correct me if I'm wrong, figures about what the streaming industry reinvests into